Welcome back. Now we're going to start into a little bit more in depth, and of course, more definitions. And hopefully I'll help you remember some of these. Chapter 7, we're going to talk about interest in real estate. The interest an individual has when they own real estate. Okay? So, first thing, limitation in rights of ownership. You know you have the bundle of legal rights that go along with owning real estate. And even the most complete ownership allowed by law is limited by public and private restrictions. So those are things we're going to be learning today in this session. You have government powers. Those are powers of individual ownership are subject to powers held by the federal, state, and local governments, such as police power, the power to enact legislation to preserve, protect the public's health and safety, that's like with zoning, promoting the general welfare. The laws have to be uniform and non-discriminatory. Zoning laws basically are more local. Eminent domain is a right our government has to acquire privately owned real estate for public use. So eminent domain is the right they have, and the process by which they use to acquire your property is condemnation. They condemn it. Okay? The property must be used for public use. You must be paid just compensation. And the rights of the property owner must be protected by due process of law. It has to go through the law. They cannot just serve you notice and say, get out tomorrow. Another one, easy way to remember this, police power, eminent domain. You can remember it by the acronym of PETE, P-E-T-E, because T stands for taxation. It's one thing we can never get away from, death and taxes. Taxation is a charge on real estate to raise funds to meet the public needs of a government. Never going to get away from taxes. Now, escheatment, different than eminent domain. Escheatment is when the government cheats you out of your property when you die. Easy way to remember it, right? So the state may acquire privately owned real or personal property when the owner dies, without a will, intestate. Okay, intestate has the letter N in it. No means no will. If you died testate, that means you had a will. Okay, so the government can end up with your property if you die with no will and you have no heirs, nobody. Do you want the government to get your property? Well, if you don't want the government to have your property, then I suggest you have a will completed, no matter what age you are. In Illinois, real property will escheat to the county in which it is located in, rather than to the state. Everything in Illinois happens to the county where the property is located in. If you're going to record a deed, you're going to record it in the county where the property is located in. If you're going to file a judgment against me, you're going to record that judgment in the county where the property is located in. Okay? So it escheats. Then when you own property, you know you have your bundle of legal rights. You have an interest in the property. Well, we have different types of estates in the property, in land. Estates in land. It's a degree of quantity, nature, and the extent of your interest in the property. In Illinois, your traditional freehold estates and leasehold estates are found in most states and are recognized under Illinois law. Freehold estate lasts for indeterminable length of time, and it includes different types of an estate. Fee simple to feasible, condition subsequent. It's like for a lifetime, it's forever. Or you could sell it. It's an indeterminable length of time. It's real property. Leasehold estate, though, that's when you lease a piece of property. That's for a fixed period of time. It includes different types of estates, which we'll talk about in Chapter 17. It includes an estate for years, and estates from period to period. A tenant has a leasehold estate with a landlord. Now, the tenant holds the property for the lease term. The leasehold estate is considered personal property, where if you had a fee simple estate, that's real property. So when a tenant leases property from the landlord, they have personal property. And then the property ownership reverts back to the owner, and the landlord has reversionary interest. So let's talk about our first estate when we own property. Fee simple, or also known as fee simple absolute. It is the highest recognized interest in real estate by law. The holder is entitled to the property, all rights, limited only by public and private restrictions. Upon death of the owner, the property passes to the owner's heirs or as provided by will. Or it depends upon how they own the property, which we'll be talking about down the road. So that's the best type of ownership you can have, and that's probably what you would want when you own a home. Fee simple defeasible is subject to an occurrence or non-occurrence of some specific event. It's a memory tip, basically. You will see, if it's a defeasible estate, it'll see words such as while, during, while you own it, during your ownership, etc., etc. I'll give you a good example. I sell you my house for $50,000 as long as, or while you own it, or during your ownership, there's never any alcohol consumed upon the property. Now, if you consume alcohol, the property can revert back to me. Or I can have it go to a third party or remainder person. That's a defeasible. It's basically subject to, or while, or during, subject to an occurrence or non-occurrence. It's not fee simple absolute because there is a limitation there. Condition subsequent, you will see the words on the condition that. The new owner must not perform some action or activity. If the condition is broken, the former owner may take possession of the property through legal action, the right of re-entry. Many religious buildings are sold on the condition that it remains a religious building for X amount of years. That's a condition subsequent estate. It's on the condition that. So remember those key words to tell you what type of estate you have. Also, special limitation, the estate ends automatically upon the current owner's failure to comply. Also called a fee simple determinable. And you have the right of re-entry or reverter. Re-entry or reverter are considered future interests. Reverter, think of rewinding. Think of things going backward. It goes back to the original owner. Okay? Remainder goes out to a third party down the road. Now we're going to talk about life estates. There's two types of life estates we're going to talk about. The first one is a life estate based on the life of somebody. It's a freehold estate limited in the duration to the life of the owner or the life of some other designated party. The ownership may be sold, mortgaged, or leased, but it's always subject to limitations of the life estate. It's a life estate. A conventional life estate is created intentionally by the owner. The life tenant has full enjoyment and use of the property during their life, but when the life tenant dies, the estate ends, and now the owner basically has a fee simple absolute. Or it can return to another person or a previous person. An example, you buy a piece of property. It's a large property, several acres, and there's a guest house and there's a regular home. Well, it was listed under market value. Why? Because Grandma lived in a guest house on this property. Grandma was the life tenant. Grandma cannot destroy the property, but Grandma has the right to live there for the rest of her life. Now, upon Grandma's death, the owner who bought it now has a fee simple absolute. They can lease out that guest house, they can do whatever. When the estate ends, the ownership can pass to another designated individual or returns to the previous owner. So it all depends on how that life estate is created or written. Then you can also have a conventional life estate per art travail. That's basically for the life of another. Life estate's based on the lifetime of a person other than that life tenant. The life tenant may not injure or waste the property. Example, you have a 6 flat. You don't have money to take care of your mom and dad's care, So you sign over your 6 flat to a nursing home, and the rent collected from the nursing home basically is to pay for your mom and dad's care in that nursing home for as long as they're alive. It's your property. It's given to another based on somebody else's life. It's not based on your life. It's based on your mother and father's life. Okay? Then upon death of your mother and father, the property will revert back to you, and you have fee simple absolute again. Those are conventional life estates. Need to remember, too, a couple other definitions: remainder interest, reversionary interest. Remainder, the creator of the life estate may name a remainder person, somebody that's third party in the future. If you're the remainder person, all you have is future interest. If it reverts back to the original owner, the original person, well, that's reversionary interest. Revert, backwards. There is also what they call legal life estates. Now, when you see that word legal, that means it's created by law. Legal life estates are a form of a life estate established by state law. There's 3 types of legal life estates. 2 of them we do not use in the state of Illinois. Okay? We do not use dower or curtsy. Dower is a wife's interest in a deceased husband's estate, and curtsy is husband's interest in the deceased wife's estate. I get tongue-tied at times. In Illinois, though, we have a homestead estate, okay? Now, there are some charts here that basically will explain a few things a little bit different for your fee simple estates and your fee simple absolute, fee simple defeasible. The key word is knowing the words. Occurrence to, non-occurrence, or occurrence to of a special event. Condition subsequent, you'll see the words on the condition that, as long as. So those are things for you to review those charts. And as I said, the legal life estates, Illinois has a homestead legal life estate. It's owned and occupied as your principal residence. The home is protected from unsecured creditors during your lifetime. Every homeowner in their principal residence, and you can only have one at any given time, is entitled up to $15,000 after secured creditors are paid and prior to unsecured creditors being paid. Multiple homeowners, max payout combined would be $30,000. An example: somebody is suing you currently. You have a mortgage loan on it. Well, the lawsuit went through. Now you owe them X amount, and the judge orders you to sell your property to pay them. They're not secured. They don't have a lien against your property, but the judge ordered your house to be sold. Well, first of all, real estate taxes will get paid, because real estate taxes always get paid first. Secondly, all your secured debts will get paid. And then, if you're the single owner of the property, you'll get $15,000. And then the unsecured creditor will get whatever's left over, whatever their money's there for them. So remember, it's for unsecured creditors in your principal residence. The estate extends to all type of residential property, including condominiums, cooperatives, beneficial interest in land trusts, and leaseholds. A family can only have one homestead at any given time. Now, another thing in this chapter we're going to talk about is an encumbrance. Okay, an encumbrance. Now, if it's cold outside and you put on your heavy coat, a sweater, gloves, mittens, boots, etc., scarf, are you a little bit encumbered compared to in the summer months? Yeah, encumber something, okay? It's harder. Well, an encumbrance in real estate basically is a claim, a charge, or liability that attaches to the real estate. It's a right or an interest held by someone other than the fee owner of the property that affects the title. There are 2 main classes of encumbrance we're going to talk about. One is liens, that's monetary. The other one is physical, like restrictions, easement, encroachments. We're going to talk about those. More definitions for you to learn. As I tell you, every day is definitions. Repetition, repetition, repetition. Even if you put me on at night and listen to me as you go to sleep, it eventually will get in your brain. So the first encumbrance we're going to talk about is a lien. A lien is a charge against a property, not the individual. It provides security for a debt or obligation. Key thing with liens you must remember, liens go with the property, not with the owner. Restrictions, deed restrictions, also referred to as covenants, conditions, and restrictions, or CCRs. They're private agreements that affect the use of the land, deed restrictions. No fences higher than 5 feet in this subdivision. Your front door has to be either red, white, or black. Can't have any other colors. No commercial vehicles parked in the driveways. Basically, those are certain type of restrictions subdivisions or local governments can have. And another encumbrance is an easement. Now we're going to talk about our different easements. A pertinent easement. It's annexed to the ownership of one parcel and allows the owner the use of a neighbor's land. A good memory tip for you to remember with all these definitions you're learning. A pertinent. You see the word, it has 2 P's in it? 2 parcels of property must exist for an appurtenant easement to exist. So you have lot A, you have lot B. For a homeowner on A to get to their property, they have to cross over B's land. So lot B is serving A. So lot B is the servient tenement. They serve the needed party in need. Lot A is a dominant tenement. They need it. It's required. They're the domineering tenement. Okay, servient tenement serves the other party. Hopefully that helps you out. An easement may be created by written agreement between the parties, the grantor and a deed of conveyance. Long time usage. If you start using your owner's property over and over and over again, basically you can, if it's open notorious and they don't stop you, you can end up getting an easement by prescription. And then you have a necessity, which is a court-ordered easement, or implication, implied. We've heard that word implied several times throughout this course even. Party wall easements. You own a duplex. That's 2 units built together, but you have 1 wall that connect you. That's a party wall easement. You take care of your wall, I take care of my wall, right? So it's a party wall easement. Some single-family homes in some suburbs of the Chicagoland area, you have 2 homes, neighboring homes, and you have 1 driveway. And that 1 driveway belongs to both parties. So I use the driveway to get to my garage. My neighbor uses the same driveway to get to his garage. Well, who's going to plow the driveway in the winter? Something you better work out. You better have nice neighbors, and you better be nice neighbors. But those are party wall easements. Easement by necessity arises when owners sell part of their land or their land that has no access except over the remaining portion. If somebody will not allow you to cross over and you cannot get to your land, you cannot be locked out of your land. So easement by necessity is when you go to court and Judge Judy orders an easement by necessity because nobody can be locked out of their land. Easement by necessity. Easement by prescription. You're not going to Walgreens for that one or CVS. Easement by prescription is basically the use must have been continuous, exclusive, and without the owner's approval. Over and over and over again for up to 20 years. Must be visible, open, notorious. The owner must have been known about it and did not stop you. It must be without permission. Now, I start using part of your land every spring to plant some vegetables. I plant them on mine, and I spread it out every year a little bit more and more into yours. But we share the vegetables. You take them. You even help me plant the plants. Can I ever acquire that portion that I'm using for 20 years? No, because it's with your permission. It has to be without the permission. If you stop me, then year 1 has to start all over again. Okay, so easement by prescription. In Illinois, to establish an easement by prescription, the use must be adverse, exclusive, under claim of right, and continuous and uninterrupted for a period of 20 years. 20 years. One more easement we're going to talk about. Wow, lots of easements, more than 3. Easement in gross. It's an individual interest in or the right to use someone else's land for a particular purpose. Most easement engrosses are commercial easement engrosses with utility companies. Many utility companies will have a 5-foot, 10-foot easement on part of your property where they have the right to come in and dig up. If you recall, when you ever purchased a property, your attorney may have said, based on this survey, you have a utility easement back here. Don't put anything of permanent nature because the utility company can come and dig it up. So you should be aware of that. Same thing, the utility company has the right to enter your yard to read the meter. They have that right because that meter is theirs. It's easement gross. Now, if I personally, as a homeowner, gave you an easement to park your boat on this part of my driveway, that's a personal easement gross. Most easements and grosses, the commercial ones, will transfer with the land. Most easements go with the property. But if it's a commercial, if it's a private easement gross, that a private individual gives to somebody else for the right to use. For easement, it's the right to use. Well, based on transfer of the property, that easement stops, okay? We can also have an easement by condemnation. You heard of the right the government has to take our property for public use. That right is eminent domain. They may not want your entire property. Maybe they want the first 10 feet from the street of your property to expand the street. Well, that's easement by condemnation, and they have that right because of eminent domain. So when can an easement end? Well, there's certain times easements can end. If the purpose no longer exists. What do I mean by that? Well, you have Lot A, Lot B. Now the village comes and puts up a road. So the owner of Lot A can now get to this property without crossing over B's, correct? So you don't need it anymore. Or you have Lot A and Lot B with the appurtenant easement, and Lot A sells their property and owner of Lot B buys it. So now it's one big piece of property. No longer do you need it, right? The release by the right of the owner of the servient tenement. The servient tenant can release it. Maybe you want to cross over somebody else's property. Or if you stopped using it because you found a different way. Maybe you made friends with a different neighbor. By abandoning it, the easement may end. By non-use of a prescriptive easement, if you stop using that prescriptive easement. Now, if I used that prescriptive easement for 10 years, then I sold my property, and the new buyer kept continuously planting the garden and planting it, the new buyer could acquire that portion because of the tacking. They tacked on 10 more years onto my 10 years. It would continuously go. Or the servient tenement property got destroyed. It could be terminated by lawsuit against someone claiming an easement, or by the property conversion, if the property got converted to something else. So an easement is the right. It's the right, the interest somebody has in a parcel of land, the right to use. Easement, the right to use. Now a license, and you're all working on getting your real estate license, well, that's a privilege. So currently, you're working on getting the privilege to sell real estate or lease real estate. Okay, so a license is a personal privilege to enter the land of another for a specific purpose. I'm going to let you, Mr. and Mrs. Jones, we're neighbors, you can come in every fall and pick the apples from my apple tree. I told them I'm going to let them. Did I say I'm giving them the right to? No. I'm going to let them come pick them. Well, if I happen to sell my property, do they still have that right? No. Upon transfer of the property, the license terminated. Or if they came 1 year and picked every single apple and didn't leave any for me, can I terminate that license? Yes. It can be canceled by the licensor. You're rushing to get home, or you're rushing to do your pre-licensing class, and you get a ticket on your way. What does Illinois do? They take away your driver's license, because that driver's license is a privilege. And any license will end upon the death of either party. Somebody can't use your driver's license once you're dead. It's gone. okay? It's gone. But remember, the right to use another's property that is given orally or informally a lot of times can be considered a license rather than an easement. Usually you're going to get easements, the right to use it in writing. Okay, another encumbrance is an encroachment. An encroachment. What type of encroachments? Well, an encroachment occurs when part of a structure illegally extends beyond the land of its owner or beyond the legal building lines, a shed or a fence that's partially on the neighbor's lot. Or what about this apple tree you have on your property and the branches are extending over onto your neighbor's property? Is that an encroachment? What can your neighbor do to the branch over on the neighbor's property? Sever it. Make it separate property. Make it firewood. The apples on the tree, remember, they're personal property. And if they're hanging over in your neighbor's lot, whether they're on the ground or on the tree, they're still personal property. They're emblems. Many owners of property at times in their lifetime would love to live next to water, have a property backing up to a nice lake or a river, be able to have a boat on it. Well, when you have property that backs up to water, you have water rights. And there's restrictions also. First type of water rights we're going to talk about right now is riparian rights. You see, riparian starts with the letter R. And the riparian rights are rights owners of land have along course of rivers, and river starts with an R. Streams, creeks, ponds, or smaller bodies of water. So if you own a piece of property backing up to the Des Plaines River, you have riparian rights. Now it depends whether the river is navigable or non-navigable. Depends on how far do you own. Non-navigable bodies, such as a pond, a creek, a stream, you will own up to the middle, up to the center. Navigable bodies, such as the Des Plaines River, okay, it's navigable because boats can go on it. You own up to the water's edge. And you can acquire more land or lose land based on the water's actions. Next type of water rights we're going to talk about are littoral rights. See, it starts with the L, littoral rights. They're the rights the owners who land borders commercially navigable lakes, seas, larger bodies of water like the ocean. You don't own up to the middle, ever. You have land in California, backs up, it fronts up to the ocean. You don't own up to the center of the Pacific Ocean. With littoral rights, you only own up to the high mean watermark based on the tide. Now, as I said earlier, you can acquire or you can lose land based on certain factors. A few more definitions to learn. Accretion. An accretion is an increase in the land resulting from deposits of soil by the water's actions. It's also called alluvium or alluvium. Okay? It's based on the water goes in and out and in and out, and every time it comes in, it brings deposits, right? And when it goes out, sometimes it takes deposits. But all the new deposits you acquire, that's based on accretion. Accretion starts with A, add deposits. ADD, add deposits. So A and A. Reliction, on the other hand, is when you acquire land based on the water receding. Reliction, receding, both start with an R. So you own property alongside this river, and now we have a drought in the summer. So what's going to happen to the river? It's going to dry up, correct? You'll own more land if it's non-navigable, or if it's navigable. Okay? Either way, you'll own more dry land if it's non-navigable, because you own up to the center. But one that's navigable, you will own up to the water's edge. So as it recedes, you acquire more land. Next is erosion. You know, erosion is the gradual, it erodes. Something that erodes. You know, stones that have been covered in water all these years. It's slowly eroded, eroded, eroded. It's a wearing away of land by natural forces. And avulsion, wow, did I wake up? Is a sudden removal of soil by an act of nature. Mudslide, earthquake, guess what? There goes the property down into the Pacific Ocean, right? Avulsion, sudden removal. But you still own all the way down to the center of the earth and up to infinity. So all your improvements, and maybe some of your land went down, but not everything. Avulsion. Many states, some states, but a lot of towns around the Chicagoland area, they have limitations in the summertime on if you can water your grass, or you can only water your grass on certain days, or you can only wash your car on certain days. That's based on the doctrine of prior appropriation. Prior appropriation states a landowner must demonstrate that he plans beneficial use for the water, such as crop irrigation, etc. Okay, if the state's requirements are met, the landowner receives a permit to use specified amounts of water for a limited purpose for beneficial use. You go out to the California area, there's a drought. They're limiting the use of water. How do they limit it? Well, if you use too much water, you pay a big, big penalty out of your pocket. So now out in California, you used to know all these green golf courses and that. They're not green, they're the new golden brown in California. So with those, that covers so many definitions you had in this chapter, and this chapter had a lot of definitions. So go take a rest, and let's get ready to get started in our next.